All rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time set for oral argument. In our cause number 1 CA SA23 0023, Phillips versus Schwartz, Jared Phillips, real party and interest. Counsel, we have read the pleadings. We've conferenced this case at conference this morning. Both sides have 20 minutes to present their argument. I would remind the petitioner that if you wish to reserve any time for rebuttal, that's on you. You just monitor that at the clocks at the podium. When you approach the podium, if you would please state your name and the party for whom you represent. And with that, we'll begin with counsel for petitioner.
Good morning, and may it please the court. I am Robert Hendricks and represent the petitioner appellant Ashley Phillips, and joined by co-counsel Samantha Brown. I will refer to the petitioner appellant as Mother during today's proceeding. Overall, Mother is seeking that this court overturn the trial court's ruling from the October 7, 2022 temporary orders, and specifically a 2-year stay on her dissolution, as well as overturning the January 19, 2023 minute entry denying specifically her motion to set an RMC and her motion for leave to amend her petition for dissolution. In summary, Mother's requests are based on the trial court's violations of her basic due process rights. And this has been categorized into 5 sections. One is the failure to provide Mother any notice that 25-903 or a 2-year stay was going to be a possibility at the October 7th, 2022 temporary orders. And categories 2 and 3, hearkening on her right to be heard at a meaningful time and in a meaningful manner, that this 2-year stay was issued after an accelerated, abbreviated, and virtual temporary orders where she didn't have the opportunity to engage in full disclosure and discovery, and where temporary orders by their nature are to be subject to change and non-prejudicial, whereas a 2-year stay on a dissolution is anything but.
Counsel, is it really a matter of lack of due process, or is it a matter of is your argument also based on the sort of the fundamental argument that court exceeded its authority under the statute to proceed in the manner it did?
And just to clarify, the statute is 25-903?
Yes, or subsection 5 specifically. I mean, what authority gave the court, what authority did the court have under the statutes to take up that, take up this issue at a temporary orders hearing?
And to the court's, I think, original question is correct. There is none. And it's not only a violation of due process, and maybe I lump them together as far as falling under the umbrella of a violation of due process. The court expanded its scope of addressing things that it didn't have the authority to do so at the temporary orders trial. Now, I think under 25-903, it's interesting as it's different from a couple other statutes under Title 25, where it's incumbent upon the court to find the basis to dissolve a covenant marriage before it enters a decree. And the timing of that from the beginning of 25-903, I think, is interesting because certainly it points to the fact that it can't happen at temporary orders. I do think the court has the authority to find the basis to move forward with a dissolution of a covenant marriage, but not at a temporary orders trial. It's before it enters a decree of the dissolution.
I thought the parties had a burden. A party, the petitioning party, would have the burden of proving one of the bases upon which to dissolve a covenant marriage.
And that's not the explicit language that I see in 25-903, and that's where I draw a distinction. The 2 examples that come to mind are 25-409 and 411, modifications in third-party rights, where the statute explicitly puts it on the parties to allege specific, not only statutes or legal authority, but factual as well, to avoid summary dismissal or to be able to meet the material change in circumstances. But 25-903 just talks about how the court must find the basis before it enters a decree. It doesn't put anything incumbent on the initial pleadings itself, although I would anticipate that it has to be placed before the court, but that's just not how the statute is phrased. And
well, it has to find it based upon something that's in the petition.
So I'd imagine, while it is not, while it is not explicit, it certainly has to be brought before the court. The court isn't going to investigate or conduct it itself. So the burden to me, just on a fundamental level, would fall on the petitioner. And certainly that is what...
They have the burden of production. They
Correct.
clearly have the burden of production to produce the evidence.
Yes. And so that would fall on the petitioner seeking the dissolution of the covenant marriage to bring forth the grounds to do so. But 25-903 is phrased as the court needing to make one of those findings before it enters the decree.
And a party can allege one or all of the grounds, or anywhere in between it.
Doesn't seem to be any limiting language under the language of 25-903. It has to just find one of them. And I believe anything from simply that the parties agree to it, or to prove fitness concerns, such as mother in this case, alleging things such as domestic violence, substance abuse. Then all other examples include extramarital affairs, and then there's some temporal requirements, which of course this is what the trial court found itself is common to be the case, that if it doesn't find the standards underneath the other prongs, there's two temporal requirements of abandoning domicile as well as living separate apart for at least 2 years, that the court can put a stay on the matter for it to meet the temporary requirement, even if it wasn't met at the time of filing.
Is the record clear that your client did not plead subsection 5?
Correct. Yeah, it is. That is clear that was not pled not only in her original petition, but nor in what she was seeking to do in her amended petition as well.
Well, she didn't identify any particular subsection of 25-903 in her petition, right? So I don't. If she doesn't identify any of them, why does the Superior Court not have the authority to use subsection 5 as a catch-all?
It does. I believe that it does. It just couldn't do that at temporary orders. That to me is the key. She has the opportunity in order to pursue full disclosure and discovery to prove what she believes authorizes her to be able to move forward with a dissolution of a covenant marriage without meeting those temporal requirements. But I think the language is clear, to the court's point, under the temporal requirements, that the court can put a stay on a proceeding if none of the other prongs are met, even if the petition was filed before those temporal requirements were met.
So you're saying that a party can file a dissolution petition on a covenant marriage and not list any bases?
Yes, I believe so. And
Well, what notice does that give to the opposing party of what they have to defend against at the final dissolution proceeding?
they would have, and first I would think they would have the opportunity to file a motion to dismiss in order to, especially in the event of a covenant marriage, where you have a situation where the only way to proceed with the dissolution of a covenant marriage is very specific prongs. That is very different from a non-covenant marriage.
Well, if you say that the basis upon a dismissal motion is the failure to state a basis, then haven't you also answered my question earlier about if you don't state a basis, that is a faulty petition?
It can, and maybe I misunderstood the question earlier.
Well, I think you have to at least allege a basis upon which you are going to pursue a dissolution decree for a covenant marriage.
And I would agree, and I think maybe I just understood the question earlier of who was incumbent upon to make these final findings in order to proceed with the decree. And to me, it seems 25-903 puts that on the court. It specifically says the court needs to make these findings. It doesn't put it on the parties to allege it in the initial pleadings like other statutes that I referenced earlier, 411 and 409 specifically. But it absolutely, a party has a right to notice. That's part of Mother's argument today. And it also, there has to be sufficient grounds in order to move forward with the covenant marriage for the court to actually make those specific findings, whether that's in the initial pleadings to put parties on notice, or that comes out through the course of disclosure, discovery, and final trial.
How about ARS 25-314, which says the verified petition in a proceeding for dissolution of marriage, annulment, or legal separation shall allege that if the marriage is a covenant marriage, any of the grounds prescribed in 25-903 or 25-904, whichever is appropriate. That to me seems like it's instructing that the party filing the petition has to specifically identify the grounds in 25-903 or 904 that are appropriate.
It does, and my reference earlier was just incumbent upon the court was the very initial sentences of 25-903 of what the court needs to find to move forward. I agree that there had to survive dismissal or to put parties on proper notice or to move forward, that certainly will be incumbent upon the parties to bring the appropriate grounds and factual allegations. And as far as what the statute reads is what I was trying to articulate earlier, is that it's incumbent upon the court to make sure that one of these categories are met before it enters a decree.
And so how did Mother meet that standard then in her petition for dissolution, when she doesn't identify any particular ground under 25-903 that she thinks is appropriate?
So she identifies 25-903, and she alleged the factual allegations that fall under two specific subsections, where she alleged domestic violence, which comes under a specific subsection under 25-903. She also alleges substance abuse, which is another specific subsection under 903. And she does specifically reference 903, just not a specific subsection under the two prongs, which I believe are 4 and 7, without double checking it, but it wasn't 5, which is what the trial court ended up finding the 2-year stay under after the temporary order.
And in her proposed amended petition, she did put in the specific subsections, is that correct?
That was the goal, and that's where I was the attorney of record, was to bring it more in line with the statutes and to make sure that it was clear of what subsections she was bringing it under and to not have it limiting. I thought, this seems contradictory, but I thought the original petition was too limiting. She started alleging in the original petition some specific instances, which I don't believe is required at the initial petition, which I felt was limiting to the expansive nature of what are actually falling under her allegations of domestic violence, substance abuse, and child abuse. So we were trying to bring it more in line with the specific subsections and also not limit it, but provide notice of exactly what it is that we're bringing so that we could move forward with the case under proper notice and proper full disclosure and discovery.
And I'm looking at the petition, I actually don't see a reference to 25-903 at all.
In her original petition on August 4th, 2022,
Right.
and let me reference that as well. I have a copy, as I believe there was, and if I miss. And you're correct, Your Honor. I apologize. I see the reference to 25-319. I see the reference in the title of the dissolution of a covenant marriage in the title. And I believe that I conflated her allegations falling under the subsection that she specifically referenced, 903. But I believe that the court is correct. I don't see an actual citation to 25-903 where she specifically references her allegations of domestic violence and substance abuse. And so that might have been another reason why we were seeking to amend from that perspective as well, not only to start the matter over to move forward, but again, to provide proper notice of this, not only the statute, but the specific subsections that Mother was moving forward under.
And so I guess if she doesn't even identify, she doesn't mention 25-903 or identify a particular subsection or explain in the petition, at least in a general way, why any particular subsection is appropriate, it wasn't the proper step for the Superior Court to take to dismiss the petition under the standard that you've articulated?
And I believe that was one of the questions that was, I believe it was question 3 that was initiated from this court. And I wasn't sure how to quite answer that, as I wasn't sure what exactly the point was getting to. And we struggled answering that as part of our brief as well, of what opportunities she should be given to move forward with. And hearing the further explanation of the court today, I believe so. I don't know if there was proper notice, if we're going to look even under a dismissal standard, if that's what the court is getting at. The concern that I had, and that was outlined in the brief, was if we move forward with a response and the other side does not agree to the dismissal, a voluntary dismissal, it needs to be stipulated to or motioned. And I don't know if that's quite what the court was seeking its answer to from that particular question. That was the one that we struggled with the most as far as answering it from a dismissal perspective.
But Father never moved to dismiss this petition.
He did not, and why Mother may feel that his position is contradictory, it seems that while he doesn't want the dissolution, he doesn't want it to be dismissed. And if I remember correctly, there was argument in the answering brief to preserve the service date to sever the community moving forward, as that would be preserved if the stay continues, and then they ultimately move on with a dissolution decree in whether it's 2024 or 2025.
So let's assume for the sake of argument that there should have been an amendment and she didn't include the 2-year subsection. There's a final dissolution hearing, and the court again finds that she hasn't proved the domestic violence or the substance abuse. And so she hasn't proved her allegation for the basis. At that point in time, since she hasn't designated the 2-year provision, you dismiss the petition. That means all of the community property from the point of, it's all community property again. It's as if nothing has ever been filed.
Correct. Yeah, that would be my understanding as well, because when the decree is entered, it goes to the retroactive date of the date of service. But if decree is never entered, then the community is just continued.
Well, isn't that prejudicial? Wouldn't that be potentially prejudicial to one or both parties here?
To either preserve it or to dismiss.
To dismiss, then if
Potentially, and I believe that's Father's argument, is that that could be prejudicial to him. The contradictory nature that I find in that position is yet he doesn't want to move forward with the dissolution, but yet he wants to preserve the date of service for when the dissolution, I guess, ultimately happens. So to me, if we could move forward with the dissolution, the parties could agree and we wouldn't be here today. But that could be potentially prejudicial to lose that date of service when it comes to not only division of assets and debts, but support issues as well.
Well, but not to put words in Father's mouth, but if he admitted to one of the allegations that she's alleged, domestic violence or substance abuse, that would affect his parental rights, correct? I mean,
Yes.
there's a reason why he wouldn't want to admit to either one of those as a basis.
I apologize, let me clarify. One of the prongs under 903 is the parties can just agree to the dissolution. I didn't mean to say that he would agree to Mother's allegations, so I apologize. I was referencing, I believe it's subsection 8, that the parties can agree to the dissolution. So with that, briefly, so I reserve a few minutes on notice. Just wanted to make clear that there was no notice provided to Mother that 25-903 was going to be at issue for the temporary orders because it was never alleged in her motion, and more importantly, in the order to appear, only referenced her motion, which was specifically only touching on temporary orders and specifically exclusive use of the residence, legal decision-making, parenting time, and child support. The other aspect, too, is I know that Father alleges that there was notice provided at the hearing itself, but in accordance with the context of the transcript, it appears that the court's 2 references to a stay initially at the beginning of the hearing was in regards to Father requesting for conciliation services, which automatically triggers a stay while that proceeding is pending. And at the end, I will admit contextually, it does appear that the court is referencing a stay under 25-903, but certainly notice at the end of an evidentiary hearing, temporary or not, certainly wouldn't be proper notice that that would have been at issue going into that hearing. And as far as categories 2 and 3 for the second half of what Mother alleges was a violation of her due process was the opportunity to be meaningfully heard at a meaningful time. And we were dealing with a situation where the temporary orders trial was set approximately 5 to 6 weeks after her original motion, which certainly didn't give either party the opportunity to complete full disclosure and discovery. It was in the matter of about 25 minutes each in terms of testimony. And the case that's outlined as far as answering the brief, I believe, is Dario, if I'm pronouncing that correctly, which has similarities between Mother's arguments in this case as well as the arguments that were made in that one, but I believe some clear distinctions can be drawn between the two. In Dario, the emergency motion and the petition were contingent upon each other. It appeared that in Dario, the emergency motion and the petition to modify parenting time was a mere days after the prior orders were already entered. It didn't seem that Mother would be able to even move forward with any type of petition to modify parenting time running into the 25-411 12-month requirement, but for an emergency. And when the court didn't find that there was an emergency, then there's no basis for her to move forward with her petition to modify because you run into that temporal requirement. This is distinctly different in this matter than Dario. There was not an emergency to dissolve a covenant marriage. There was an emergency to modify parenting time in Dario, which is very different factually. And in Dario, it appears that there was one emergency incident. and it had to do with a taser and between father and the child in that case. Whereas this, we're not talking about a singular emergency incident. Mother is alleging a history of domestic violence, a history of child abuse, and a history of substance abuse that certainly cannot be given a meaningful time and a meaningful opportunity to be heard in the matter of weeks, when she had the opportunity to pursue therapy records, medical records, rehab records, obtain experts, motion the court for evaluations and investigations that simply couldn't be done on a temporary basis. Nonetheless, the fact that all she was seeking were temporary orders, which on its face and in the October 7th, 2022 minute entry itself outlines how they are non-prejudicial, subject to reassessment, specifically because the parties haven't been able to engage in disclosure and discovery. And just very briefly, we also argue that forcing the 2-year stay upon mother without the opportunity to exercise her due process invokes concerns with public policy and a possible chilling effect on seeking temporary orders if they're going to be held to almost the standard of a final order. And it was an error by the court and abuse of its discretion to deny her motion for leave to amend when those should be freely given. And in the half minute that I have left, I'll reserve that for rebuttal.
All right, thank you. Counsel?
Yes, good morning. May it please the court. London Garrett on behalf of the real party in interest, Jared Phillips. I would like to begin by addressing some of the issues with the motion to dismiss versus moving forward with the temporary orders and issuing a stay. To begin, filing a motion to dismiss or having the petition dismissed, yes, it is prejudicial in the sense of what it does to the community. Delaying the severance of the community by 2 years is quite significant to these parties should the dissolution move forward. While my client is a man of faith and does not want a dissolution at this time, he can't stop it from happening if wife maintains her position until June of 2024. So if that is to occur, then the severance of the community should stand. More importantly, now that parenting time orders have been entered, those go away if the petition is dismissed. Coming into this matter, my client was unable to see the children in any substantial fashion. Mom was mostly withholding the children due to her allegations. The temporary orders decided exclusive use of the home, granted my client equal parenting time in a step-up basis, joint decision-making, and entered child support orders. If the petition was then dismissed, any underlying temporary orders would go with it. And so at this time, yes, my client is not in a position that he believes that the petition itself should be dismissed, and it would be prejudicial to him and potentially both parties when it comes to the community. When addressing the allegations in the petition, while it did not give specific citations, it was pretty clear what wife was intending to imply in her petition. It is sections 4 and 7, which is for domestic violence, specifically physical, emotional, verbal abuse towards her and the children is what she placed in her petition. And then she also claimed substance abuse, specifically alcohol. All of that did appear in her petition. She simply didn't cite a statute. But ultimately, we understand that a covenant marriage is going to be governed by 25-903. And based on those allegations, that would trigger 4 and 7. That is what we prepared to defend against at the motion for temporary orders, because the motion for temporary orders made these same allegations. If I'm correct, I believe it was actually filed as an emergency motion. It was denied on an emergency basis, and it was scheduled a few weeks after her filing. Again, the time...
Let me jump in here. So what gives the court the authority to discuss or even consider or even the parties to bring up the grounds for dissolution at a temporary orders hearing, as opposed to other very important things like legal decision making, parenting time, etc., like what was discussed here? Those are not grounds for dissolution. Those are handling the urgent needs of the parents and the children. What authority is there for the court to jump into all of a sudden, right out of the gate, into the grounds for a dissolution of a covenant marriage?
In this scenario, our position is because they overlap. Pardon me. 403, the allegations under 903 that wife was bringing, when compared to the best interest factors, domestic violence and substance abuse are going to be addressed at that trial every time. It's very important for the best interest of the children. And so because they were inherently linked and there's no way to separate the two, then at that time, the court could assess were the allegations brought under that petition true, and if not, then what must the court do next? Our position is that you have to issue the stay, because Section 5 of that petition, or of the statute specifically.
Did you allege that in your pretrial statement before the temporary orders hearing?
Which part of it, Your Honor? I apologize.
That you should enter a stay, that she hasn't proven the other bases.
So we do have a section in our pretrial statement where we specifically acknowledge that we do believe that she was making these allegations to get around the requirements of 903. And that was cited to by the judge at the top of the evidentiary hearing.
So you specifically requested that he issue a stay in your pretrial statement?
No, in the pretrial statement, I believe I misspoke and said motion to dismiss, that one would be pending, it would come. But it would be a motion to stay because the court can't dismiss under 5. So, but we do have, I believe, 903.5, apologies. We have 2 or 3 paragraphs in our pretrial statement before we get into the best interest factors focused primarily on what we believed wife was doing to get around the 903 factors.
What do you mean get around the 903 factors?
Apologies. So,
I mean, but get around, if you start out by saying subsections 4 and 7, that it was clear to you that that's what was pled. So what authority does the court have to sua sponte raise subsection 5? It was not pled. What do you read in the statutes that gives the court that authority?
So in 903, 1 through 8, any one of those could trigger the ability to file a dissolution. And so it's our position in the reading of 903, because it's an or, only one of those has to be met, that the trial court is obligated before issuing any form of a dismissal to review all 8 factors there. Wife did not allege any adultery or any felonies that would trigger the other elements of 903.
Typically, a petition you have to plead it and prove it. And I don't see any distinction for a 903 petition why a party wouldn't have to plead one of the bases and then prove it. And here she pled 2. So what authority, and I'm going to what Judge Brown was asking, what authority does the court have to plead a different one?
Ultimately, it's our position, I apologize, but there's not a specific statute, a specific case law that answers to this.
Well, the 25314 says that the individual filing the petition has to assert the grounds whichever he or she thinks is appropriate. So I think there is a statute that addresses this issue. It cuts the other way.
Well, I believe she did assert the grounds in her allegation. She just failed to issue a citation. So she did assert the grounds. The standards were there, specifically 4 and 7 for domestic violence and substance abuse. She did not make any statement to Section 5. And I believe the question at this time, if I'm correct, is that how could the court issue an analysis under 5 if she didn't cite to 4 or 7? Or if she did cite to 4 or 7. And my position is...
No, the position is how can they find it under 5 if she didn't plead 5? That's the question.
I believe the court has to do a full analysis of 903. Whether it could be... The petition itself is under 903, the entire statute.
So if a party pleads domestic violence, that's the only basis upon which they plead. And then at a final dissolution hearing, there's a lot of evidence of substance abuse has never been pled. You're telling me that the court could simply say, yeah, you didn't prove the domestic violence, but I find under a different basis, never pled, that I can issue this dissolution of a covenant marriage.
If they were able to survive to get to the final evidentiary hearing, and that did appear in a pretrial statement or something that wouldn't be trial by ambush, I do believe that the court would have the authority to issue a finding under any of the prongs of 25-9.
Well, actually, that's why I asked you if you put in your pretrial statement that you wish to amend your answer to include subsection 5. And your answer to me was no.
That is correct, Your Honor.
Okay.
So, apologies. I believe that some of the other issues at hand come down to whether or not she was entitled to a second evidentiary hearing to address her allegations, specifically 903. Our position is that because you can't separate...
Don't we always give the parties in a domestic situation 2 hearings, temporary orders hearing, and then a final hearing?
Yes, Your Honor. But I believe a final evidentiary hearing would be inappropriate If a decree can't be entered,
Well, we don't know that because they haven't had a final hearing, have they? She hasn't had the opportunity to make her final argument or make her final presentation.
it is correct that she has not been able to make a final presentation, but she has been able to present the allegations that were in her petition in full.
In a truncated fashion, 25 minutes.
Yes, though it didn't seem that she had any issues getting through the timing. The court did not cut her off. The court did not stop her from presenting her case. It did not stop her from entering any exhibits. So it is our position that she did get to present her allegations, specifically in her petition. And as counsel had noted in the original petition, they were very specific about the incidences of domestic violence, specifically 2 physical assault allegations, 2 very specific incidences, both of which were heard and adjudicated, and the court did not find them to be incidences of physical assault or domestic violence. So she was given the opportunity, even in those 25 minutes, to present her allegations. She presented a form regarding my client's substance abuse. She was able to present her testimony on the domestic violence.
Ms. Garrett, is there anything that would indicate or give to alert mother that at this temporary orders hearing, it was all or nothing as it relates to not the temporary order, but the covenant marriage allegation?
There was not anything written and clear by the court. There was no indication that at this hearing that a stay could occur until the end of the hearing, when the court did advise her that that could be the option.
And your client didn't move under 25-316 to have the grounds for dissolution of covenant marriage decided in the context of temporary orders, right?
No, Your Honor, we did not. So we did acknowledge it. We did believe she was trying to get around it. We do believe that after that hearing, the proceeding should have been stayed. She just didn't meet her burden under the allegations, and the court just consolidated the 2. We find it to be appropriate in the sense that from the date of her filing, she should have understood that 25-903 is a requirement, that there are 8 options to be able to get a covenant marriage dissolved. And if you can't meet 7 out of the 8, you have to wait 2 years. And I believe I never answered that question when I'm talking about getting around 903. I'm referring to the temporal requirement of waiting 2 years if you don't meet any of the other.
So while you wait, you can't do discovery, you can't have disclosure statements exchanged, you have to put everything on hold for 2 years? Is that your position?
It is my position that yes, that should occur. Ultimately, because you shouldn't be filing the petition to begin with. You do have to wait. There is a reason that 903 and covenant marriages stand as they are.
Well, I would tend to agree with you if that was the only subsection pled. If you were only going under the 2-year ground, then that makes total sense. But here, you've already conceded, it seems to me, that she pled 2 grounds, 4 and 7. Why isn't she entitled to prove those, just like in a regular divorce, after discovery, after disclosure statements are exchanged, after sort of due process, exchange of information, ability to seek subpoena, pertinent documents? We haven't had any of that in this case, have we?
I believe we issued discovery requests, but I don't believe they've issued any subpoenas or anything like that prior to the temporary orders. The temporary orders happened.
But those are on hold now? Or is everything on hold?
Yes.
Everything?
Yes, Your Honor, everything is on hold. Ultimately, I believe this action was filed pretty quickly thereafter, so there was not really an option to get anything moving in that regard. I do believe Mother has been doing some collection of evidence in the background per her filings, which is her right, and should she find anything that's able to substantiate her allegations, then I imagine she could file a motion to lift the stay. But at this time, the allegations that she has presented, she has already tried during an evidentiary hearing, and the court did not find in her favor. So I believe that when it comes to the disclosure...
See, I struggle because the temporary order statute specifically says that it's without prejudice to the parties at a final hearing. Right?
And
So why isn't it just a complete violation to say, oh, you didn't prove this adequately enough at your temporary orders hearing, so I'm going to prevent you from going forward with this and proving it at a final hearing? That seems like it's prejudicing the party.
I believe that if she was able to obtain additional information that could prove her allegations, she would be able to get the stay lifted. I don't believe that the stay is permanent. The temporary orders are not permanent in nature. There is a way to get around it. The issue being that she is the party that caused the evidentiary hearing to occur on the timeline that it did, being the party who filed the emergency motion, being the party who objected to the continuance we requested at the hearing. If disclosure and discovery was a concern, should have been a concern at that time as well. The children were being withheld. We agreed to stipulate to her having exclusive use of the home, but she did not want to wait, and she wanted to present her allegations that day. And they're allegations about the safety of children, which is incredibly important, and if she considered herself unprepared.
But how would that look? She'd file a motion to lift the stay, attaching new evidence that she independently discovered on her own?
I believe if she could file a motion to lift the stay and then state what has happened in the interim or what additional information. The trial court did note that disclosure and discovery was not completed. And so she were noting that she continued disclosure and discovery. And I'm sure if she issued discovery requests upon my client, he'd be happy to answer them. The stay is relatively similar to the dismissal calendars. It's just we didn't have that opportunity to discuss what that looked like in the background. But yeah, I do.
It's not the same as putting it on the dismissal calendar. A dismissal calendar is simply a placeholder for the court to say, we're going to have, either we need to resolve this or file a motion to set by a particular date. This is an actual stay, telling the parties, don't do anything.
I believe that at any time, if anything new arose, she could file an emergency motion, she could file a motion for temporary orders, she could file a motion to lift the stay.
And if that was done, do you believe she's entitled to, or is it appropriate for her to amend, or let me phrase it a different way, is your client prejudiced in any way if she amends the petition?
I don't believe the amendment of the petition carries much weight with the trial court's decision. Our issue with the amendment of the petition was that it didn't actually accomplish anything in the sense that it just added a citation, it removed specifics, but it was essentially the same.
So it wouldn't be prejudicial?
To amend the petition, it would not be prejudicial. The allegations are essentially the same. It's just that the motion to amend was paired with the motion to set an RMC, and it was clear that the intention was to try and lift the stay on the matter, but the stay was not implemented because of a faulty petition.
Temporary orders has a specific connotation. There's a statute that governs temporary orders. Could you tell me which statutory provision authorized the court to do what it did in this case under temporary order statute?
There was not any specific language that would authorize.
So the answer is it does not.
No, the temporary order statute does not.
So the court on its own, just inherent authority, issued a stay?
I believe the authority to issue the stay is under 9035. I believe the court, even if she did not cite to 9035.
Without a motion. I mean, without your client filing a motion, without a motion to dismiss, the court just on its own, after hearing a temporary orders after presiding over temporary orders hearing, which has a limited scope and limited authority to enter orders, on his own issued an order that affects the party's ability to proceed, and that's okay.
When the facts of that hearing overlap with the facts in the underlying petition, I do believe it's okay. If she was alleging something under 9031, which is adultery, it would be completely improper because the trial court would not have allowed any evidence about adultery under the 403 factors. It would have been completely irrelevant. At that point, she would have had the argument of, I was not able to present my case. I did not have a fair opportunity to present my case. That's not the issue here. Her issues are domestic violence and substance abuse, which are in the 403 factors, which do get addressed, which were addressed, which her testimony was directed towards for the entirety of her testimony during that evidentiary hearing. So I believe that it's 9035 specifically that gave the court the ability to enter that stay because the court is required to enter a stay rather than dismissing if the other prongs are not met and they have to implement the temporal requirement under Section 5.
Can the Superior Court grant dissolution based solely on the testimony that's found at a temporary orders hearing? Do the opposite essentially of what the Superior Court judge did here?
grant a full dissolution? No, because, Your Honor, because ultimately the scope of the hearing would not cover all of the assets in the community property and all of the topics that would be necessary to address a dissolution action.
Say that those were all agreed upon.
If they were all agreed upon, then there probably wouldn't be a need for a temporary orders evidentiary hearing, and it likely would have been converted to a final.
No, if the assets were agreed upon, but the father was still contesting the grounds. He was contesting that there was any abuse, whether alcohol abuse or physical abuse, and the court ruled against him, then it's game over then, right?
Yeah, I would find it inappropriate at a temporary orders motion to enter a final order, which is a dissolution action. A stay is not a final order. So I do believe that at temporary orders, and that is one of the arguments that was made by Mother, which is you're not supposed to have final temporary orders. Here, these orders aren't final. They could be modified through motion. It is not a dissolution. It is not a final order under the Arizona Rules of Family Law Procedure. And so we do draw that distinction. And in my final 30 seconds, I think the main point here is just to kind of acknowledge that Mother did have the opportunity to present her case, that the issue at hand isn't actually an inappropriate petition, as that is not the trial court's grounds for having stayed the motion. Instead, she had the opportunity to present her allegations. The court heard the facts. And when the court did not rule in her favor, she took issue with that order, but ultimately she did have the opportunity to present all of her allegations at that hearing. Thank you.
Thank you, counsel. Any final word?
Just briefly, as far as the line of questioning regarding a stay and a motion to lift stay, I point to the January 19, 2023 minutes where the trial court wrote, "The court has concerns about Mother's reasons for seeking amendment of the underlying petition prior to the passage of the 2-year period. Mother's arguments regarding presenting evidence seem to suggest that if she is permitted to amend the petition, she will then seek to circumvent the 2-year period and relitigate the temporary orders despite this matter being stayed," which I think points to the court's concerns and the prejudicial nature of the temporary orders ruling on the 2-year stay, that there wouldn't have been help with the motion to stay, there wouldn't have been help with disclosure and discovery from the court, there wouldn't be cooperation from father. And that evidences the prejudicial nature of the temporary orders 2-year stay.
All right, thank you, counsel. The matter is deemed submitted. We'll issue a decision in due course.